Good evening, friends. A very warm welcome to another edition of the Media Foundation IIC Media Dialogues, which are debates that we do periodically on trends and issues related to the media in our country. Today's topic is new broadcast bill, regulation or control. This is, of course, the draft Broadcasting Services Regulation Bill, which was put out by the Ministry of Information and Broadcasting last month. It has some provisions that have significant implications for broadcast media, digital news, as well as video on demand streaming platforms, although we will focus chiefly on the first two today. Now, to discuss and analyze this bill, we have an absolutely stellar panel, as you can see. And I now request Media Foundation Chairperson, Mr. Bharat Bhushan, to say a few words about our organization and introduce the panelists to you. Bharat, over to you. Thank you.
You have to share mics.
That's okay.
You have to share mics, unfortunately.
Thank you, Seema.
When Nikhil comes here.
Good evening, friends. I welcome you once again on behalf of the Media Foundation to this media dialogue. Some of you already know what the Media Foundation is. For the benefit of those who don't, let me tell you briefly who we are and what we do. The Media Foundation was set up in 1979 in the wake of the emergency. It aims to uphold and promote freedom of speech and information, and it aims to enhance the quality of our polity through the media and the processes of communications that we use. Its founding members were B.G. Varghese, L.C. Jain, Prabhash Joshi, N.S. Jagannathan, Ajit Bhattacharjee, all giants in their fields. The Media Foundation does a few activities every year. The Media Foundation gives the Chameli Devi Jain Award to an outstanding woman media person every year. It also organizes the B.G. Varghese Memorial Lecture, our founder. He passed away in 2014. Distinguished speakers in the recent past have included former Vice President Hamid Ansari, Gopal Gandhi, Justice Madan Lokur, Alan Trussbridger, editor of The Guardian. This will be held in March in the coming year, the next lecture. The foundation also launched the Media Watch website, thehoot.org, in 2001. The Hoot was one of the first media monitoring websites in India for 15 years. It was the most respected media watch sites in the country. However, unfortunately, for a variety of reasons, it's closed down. We also organize quarterly media dialogues every year on subjects that impact the media, as Shuma already told you. Today's dialogue is part of that series of media dialogues. The subject this evening, as you already know, is New Broadcast Bill, Regulation or Control. We'll be discussing the possible impact of the new Broadcast Services Regulation Bill, which the government has released and put up for discussion and feedback. The last date for giving feedbacks, I think, is December 9th or 10th. So whatever comes out of this discussion, hopefully we'll also submit it to the government as feedback of the Media Foundation. The bill essentially provides regulatory provisions for various broadcasting services under a single legislative framework. It seeks to replace the Cable Television Networks Regulation Act of 1995 and other policy guidelines currently governing the broadcast sector in India. Welcome. The bill extends its regulatory purview to encompass broadcasting OTT content, digital news, and current affairs, currently regulated through IT Act 2000. It also includes provisions for emerging broadcasting technologies, which means all these YouTube channels, digital platforms will all come under this act. It introduces, significantly, content evaluation committees for self-regulation and a broadcast advisory council to advise the central government on program code and advertisement code violations. That's why we are asking, is it regulation or is it control? How much of it is regulation, how much of it is control? The bill has provisions for penalties like issuing an advisory, a warning, censor, and imposing monetary penalties on operators and broadcasters. For very serious offenses, there's a provision for imprisonment and also fines. Now, to discuss all these aspects, we have with us a very distinguished panel of experts and an equally distinguished moderator. We have with us Ms. Barkha Dutt. She's one of the most well-known faces of Indian TV journalism. An award-winning journalist, she's the founder editor of the YouTube news channel Mojo Story. We have with us Mr. Jawhar Sircar, a distinguished civil servant and a public intellectual. He is the former CEO of Prasar Bharati. Now he is an MP in the Rajya Sabha and a member of the Parliamentary Standing Committee on Communications and Information Technology. We have with us Ms. Seema Chishti. She is the editor of the critically acclaimed and iconic online news portal, The Wire. Prior to this, she was the editor of the BBC World Service in India and deputy editor of the Indian Express. We have with us Mr. Abhishek Malhotra, founding partner at TMT Law Practice. He is an expert on emerging issues and regulatory changes in the area of technology, media, and telecommunications. Then we have with us Mr. Nikhil Pahwa. We're lucky to have him, largely because he hurt his foot, otherwise he would have been traveling. So welcome, Nikhil. A well-known digital rights activist. He's the founder of MediaNama, a mobile and digital news portal. And finally, our distinguished moderator today is Professor Vibhodh Parthasarathy. He teaches media policy at the Center for Culture, Media and Governance at Jamia Millia Islamia. His edited books number many, but they include particularly a double volume called Indian Media Economy and Platform Capitalism in India. Vibhodh, now the floor is all yours.
Just a sort of quick thing, this was not the first attempt at having a integrated regulatory framework for broadcasting in India. Yeah. The last one was in 2007. Mr. Sircar, you were there in the government at that point of time. What's the most striking difference between the 2007 bill and the bill which is right now being presented?
That bill was equally horrendously big, and this one is also very, very big. That one had 66 definitions. This one has, I think, 56 definitions, but that doesn't make it any easier. That bill did not have any evil intent behind it, whatever be the words. The wordings and others may remain largely similar because that was also a huge bill, and once we have a huge bill passed by law, bureaucrats tend to get comfortable like their pillows. So you don't have to go and fight for every clause again and again. So it's largely taken from that bill, expanded further, put in, OTT has been put in, and surreptitiously, I would ask Abhishek to have a good look at what I'm saying, or even Barkha because she's affected. In the name of regulating OTT, I have a feeling because of certain wordings in certain places that they are getting to YouTube channels as well. They haven't come up with YouTube channels, Ravish Kumar or Barkha Dutt by name or something. They haven't come to use the word YouTube channel anywhere, but everything about it indicates. So OTT regulation, well, it's 50-50. It sort of gets into the creative spirit, it gets into a lot of other things and brings in unnecessary compliances and then a tendency towards Godi OTT. That's exactly what they want, Godiism. But YouTube channels and digital channels have come out as a form of space for us. That space is anathema. So both the IT rules of 2000, was it 17? 21. IT rules are 21 and this have to be read together. Now interestingly, Parthasarathy, watch this. There are two ministries operating. And having worked in the government for about 4 decades, I know that two ministries don't talk to each other. No two ministries. And I used to always wonder why are they always fighting. Now I'm so glad they are fighting. Because had they been kissing and making up, there would be no space for human society at all. So there's a tussle in this act also between what the Ministry of Broadcasting wants as its domain and what the Ministry of IT wants as its domain. So one wants the content, the other wants the carriage.
We'll come to that as we go forward. Since he had mentioned you, Abhishek, in the 2007 bill, section 4, they talked about a content code compliance. How is that different from the kind of content code regulation being proposed in the 23 bill?
So, it's when you are trying to make a differentiation or comparison between the two bills, it's not just the language of what is spoken about, which is the content code, so as to speak, but it's also the impact of non-compliance and the environment in which we are operating in 2023 vis-a-vis 2007. So I'll just give my answer will sort of address both aspects. In terms of the content code, because they're not alluding to any notified program code or an advertising code, they just use those terms. At this juncture, because we don't have anything, and Section 4 of the older bill specifically said that till such time that there is a notified program and advertising code, they will look to rules 6 and 7 of the cable television rules. And I take it that in the event that this particular bill is notified in its present form, then they will possibly either copy paste or refer to those provisions. Now, very often, stepping back, the bedrock of media and of content communication in the country is Article 19(1)(a), which is the freedom of speech and expression. But as we all know, it is not an absolute right. It is subject to certain limitations which are prescribed in Article 19(2) of the Constitution. Now, those are very specific heads that have been notified in the Constitution itself, and those are 8 in number. If you read the program code as it exists today in Rule 6 of the cable television rules, that's much wider than the scope that is provided under 19(2). For example, one of the first clauses of Section 6, Rule 6(1) talks about content which is not in good taste or decency. That's not what 19(2) talks about. It's way beyond that. And what is more important and problematic is that both under the amended cable television rules, the amendment came in 2021, and what is also there in the IT rules of 2021, is that there is a 3-tier structure to address what exactly would be an interpretation of what is in good taste or decency. And that first tier, of course, is with the broadcaster themselves. Second tier is also, not so bad because there is a self-regulatory body which will be hearing appeals. But the third tier, which actually is the oversight mechanism, is actually composed of government. So it's a clear violation of the separation of powers that we have in the Constitution, that when the executive notifies something, which is an implementation of what the legislature said, only the judiciary has the power to say whether this is in violation or not. One of the matters that I'm actually currently dealing with related to this program which was earlier shown on AXN, then on Sony, and then on Viacom. It is called Fear Factor. Khatro Ke Khiladi is the Hindi version. And of course, people know when you are looking at that particular program, there are certain instances, of course, the trained people that are going there, their animals are taken care of properly, etc. But nevertheless, some people may not like it. Now, that was sought to be stopped in the head of this is not in good taste and decency. So I said, whose interpretation is it?
Sure.
So that's the impact that we're likely to suffer.
Sure, thanks. Mr. Chishti, so what are your apprehensions, because you are a news website which also has a bit of video, and you're multilingual, okay? So first 3 apprehensions that come to you.
So 2 very broad overviewy points, which is why I think this is kind of a dangerous bill and it needs to be torn up. Because in its very sort of essence, it is putting in place an architecture which intends to codify what we know now as the chilling effect, like people are getting called up, all the sort of stuff that you're hearing is happening without the need for law. You hear about phone calls, you hear about pressure, all of that is finally finding its space being codified into law. So 19(1) was mentioned. This is really a blueprint for 19(2) taken way beyond. So it's like almost the whole thing about all that thou shalt not do. And as the press in India, we sort of are, we're very precariously placed. We have nothing explicitly kind of saying that there shall be a free press. We derive from what all citizens kind of derive from, Article 19(1). So I really worry about it. And the second point of government now bringing in news, which you find on YouTube, which you find in various ways. In fact, part of programming is a word which starts with W, is writing.
So I checked with a few lawyers, does this writing mean, written stuff on the website, not just AV? And they said, yeah, it could. So maybe if you push them to the wall, they'll say, no, this is just the caption Barkha puts on her show, or what our YouTube artist puts on their show. It's just a subtitling. But no, it could actually mean all the writing we do as well. So the ambiguity of taking everybody into a government tent, so the way in which the whole editorial phrase is being put out by replacing it with a content evaluation committee, which will see every bit of stuff that we put out. So it's, I think, a en masse attack on any kind of independent journalism and press under the guise of regulation. So I think there's nothing regulatory about it. This ain't no Ofcom. This is clearly the government stepping in and saying, we will tell you what's okay. And by saying that we're doing it for, if public order and integrity of India and all, no, it's about making sure that the government doesn't get displeased. It's very clear in the way it's being kind of put out. So for me, the most dangerous thing about this is the way in which you're dragging in journalists into a CBFC structure. So I'm not saying that it's good to have a CBFC structure or that OTTs should be censored, no. But so far, you've never had news coming into this kind of a CBFC setup. And in any case, even as far as film certification goes, the Shah-Benegal committee has made it very clear that it needs to be freed up much more. Instead of that, you're pushing all of us into the bottle of a much kind of a more restrictive censor network. So this is really a blueprint for censorship. So I don't even know if I'm asked, I have issues, which I'll come to that in, later when you come to me, on what clauses are of particular concern. But I think the whole conception of this bill is actually to put us all, gin, jelly, jam, news, entertainment, OTT, everybody into a box and then censor us. So that's my concern.
Sure, thanks. This is to Ms. Dutt. The whole issue about, you were a broadcaster earlier, and you kind of left that world and you're going online. But now you are being defined as the broadcaster. Yeah. How does that sort of change the way in which you're approaching the medium?
I mean, I don't think the problem is the nomenclature broadcaster. I still see myself as a broadcaster because I am a video-first platform, as opposed to many others who are text-oriented. But I think it's important to understand that there have been small creeping changes that have already come in. And it's important for us to recognize that the most problematic thing for me, and I don't speak as an expert but as a practitioner, about this proposed bill is how it clubs different technologies, different platforms, and also different sizes of media organizations. Now, why is this important to understand? Because many of us have now migrated out of television into the YouTube-driven, YouTube first, but not restricted only to YouTube space. We did that for various reasons, but in many parts because we got disillusioned with what was happening in the television space, right? And we thought here was a space, it didn't have to be giant, you didn't have to be big media, you didn't have to be corporate media, you could genuinely be honest to your own authentic sense of what journalism should be. Now, what are some of the changes that, by the way, have already come in? I don't know how many of you knew the fact that at one point, if you were a digital platform, you were allowed to raise money from outside India, no questions asked, right? Foreign direct investment, 26%, no questions asked. Now, those rules have changed. Now, nobody has come and announced them and made a big announcement of them, but it directly impacts capacity to raise money. Let's start there. Then there was this idea of a grievance redressal mechanism that was brought in for all digital platforms. So we were told that you will now have to have a grievance redressal officer. Now, in of itself, it sounds perfectly innocuous. The audience should have some sort of, way to tell you we have a problem with your story. But what do you do if, for example, I do a program, as I do every evening, which streams live on my platform, and I have 100 people who write in an organized way, much like trolls on Twitter, or X as it's now called, and say, we are offended by this, right? Now I have to, as a small sort of 20% organization, spend money on having one person who will sift through all of these replies and reply to them, right? Two, if need be, I have to hire lawyers, and I think a lot of us have got by because we have friends and family who are lawyers. Literally, I'm being that honest that the kind of things we deal with, the first pressure is financial pressure. The first pressure is to complicate your financial viability. I think everything else is a meta discussion. It's a philosophical discussion. What are the boundaries of Article 19? What are the restrictions? But if you can't pay for yourself, you can't, pay your salaries, you can't scale. And if there is an obstruction to that process in policy, that to me is insidious because it doesn't get as much attention. But to me, it's actually the most dangerous thing. Now, coming to this, I just find myself, like, while I may think of myself as a visual storyteller, I find that to club digital with broadcast is such a problematic thing to do, because you're talking about organizations that are funded by business houses, that are cash rich, that have thousands of employees, vis-a-vis many individual. I mean, I'm still a 20-person organization. There are people who are one person plus two people. They're 3 people organizations. And if you are going to snow them under sort of legalese, complaints, somebody writing to them and saying, the advisory council saying, this is not palatable to us, what are they going to do? What are their options? Right? So the way to think about this is a little bit like I think about trolling. What is trolling in the end? Trolling is a way to control your mind. Right? It's that enough people will say something to you that you think, yaar, ye bolo hi mat, because ये रिएक्शन आएगा. मैं कुछ बोलती ही नहीं, या मैं चुप रहती हूँ, या मैं ये बोल देती हूँ because ये बोलूँगी तो सब कहेंगे वाह वाह. Right? This is a sophisticated kind of trolling of digital journalists. That's what it is. It's trolling us.
Yeah, it's a kind of, okay. So I think both points are significant. Mr. Pahwa, again pulling back to the big picture. So last year there was the telecom bill, which sort of
I was just going to
try to put everything into transmission, and now we've got a broadcasting bill, which has put everything under broadcasting. Yeah, can you just tell us really what's happening?
So it's a so one is, you can look at this as a battle for jurisdiction, because the telecom ministry comes and says that broadcasting should be under the telecom bill. MIB is sitting there thinking, hey, what job do I have if everything goes to DOT, right? So this bill, if you look at what is the reason behind this bill, there are 2 things. One, it's about MIB asserting its jurisdiction over news and also OTT streaming. The other is, let's not forget that the IT rules which came out in 2021 are essentially illegal. There's nothing in the IT Act which enables those rules. And so therefore, LiveLaw and a bunch of other players have gone to court, and I think the Wire has also gone, and they've got an injunction on the rules as such, right? So one of their arguments is these rules are illegal. If you pass a law that legalizes the rules, and let's not forget, this has been done in the past, right? In the Aadhaar case in the Supreme Court, the Aadhaar Act was passed, I think, it was listed for tabling the next day, and at 9:30 at night it was listed for tabling the next day. Next day it was passed as a money bill. Why? Because there was a challenge to Aadhaar that it's not backed by law in the Supreme Court. So you're bringing out this particular regulation in order to legitimize rules that you've created which are already illegal. So that's the 2 reasons why we're seeing this. The other thing I want to, I don't agree with the definition, that the idea that online news and current affairs and online streaming is broadcast. Let's not forget, in the Kamlesh Vaswani case in the Supreme Court, which was about the ban on porn, Mukul Rohatgi, the then Attorney General, said in court number 1 that the government doesn't want to do moral policing, it doesn't want to ban porn. This is private viewing in someone's bedroom, and so they don't want to basically ban porn. Now, structurally, if you think about it, if that is private viewing, how is online streaming not private viewing? It's the same concept.
Sorry, I just want to clarify that I don't agree with clubbing digital with cable, but I kind of wonder if we can still call digital journalistic platforms private viewing, because I think all data shows that the biggest source of news consumption now in India is from YouTube and WhatsApp.
Fair enough, but then the thing is, this is it's what happens with television as such is that you don't have any information about what you're watching, control over what you're watching. So it's pull based. 2, it's not broadcast. It's narrowcast. It's 1-to-1.
Agreed.
So structurally there is, so if you can say that porn shouldn't be banned for this reason, why is there a regulatory framework being created around online streaming and, to that effect, online news? The other thing to bear in mind is that the impact that the content evaluation committees are going to have on documentaries. You will find it very rare that a documentary in India on India, a documentary on India is going to be released in India if it is in any shape or form critical of the powers that be. And so you already, if you talk to any streaming platform, they already have lawyers in-house that have already been censoring things. There's a Washington Post story recently about something similar, but this is stuff we've been hearing about from content creators all the time. I think it's impossible and frankly a big problem to extrapolate that content evaluation framework to news. But B, even in case of streaming, you think of the cost that is incurred for every single platform, every single player to set up an independent content evaluation committee. The other thing that's going to happen is there's already a construct that exists in case of under the IT rules. There are people who have set up organizations. Digipub is one that some of us belong to. In terms of online streaming services, there are multiple other organizations that have been set up. There's a full framework in place. This framework is going to upend all of that. It's going to override it. So again, fresh investment in creating new structures, new internal regulatory mechanisms are going to be a problem. Lastly, and for me, the most worrying aspect is that there are 67 areas where rules are going to be made later. What you're seeing in multiple regulations, let's take the IT Act by itself, right? From what I heard today, there's a new version of the IT, an update of the IT rules that's expected in 7 days now for addressing deepfakes. What the government has done is it's taken power away from the legislatures and given itself executive power to make rules. You've seen it with the IT rules. You've seen it with the data protection bill. This bill has 67 areas where rules will be made. What's going to happen is there's going to be constant rule making. It's going to be, they see something as a problem, a new set of rules will come out. 5 sets of rules or 6 sets of rules have already come out. Updates of the IT rules have already come out, right? 5 updates. You're going to be constantly chasing that regulatory shift. So one is that with digital, you need flexibility in lawmaking, but the other problem is how do organizations keep adapting to new sets of rules all the time? It's impossible.
Well, this in a sense also takes us back to the early years of broadcasting where nothing was through legislation except for the Cable Act, uplinking guidelines, DTH rules, so on and so forth.
But broadcasting, the content regulation was also an independent code that was created.
Yes, I'll come to the code. I'll come to the code. But I'm saying this idea of having a kind of regulatory vacuum in that sense and then deriving powers from other kinds of legislation is something not completely new. A question in terms of the news outlets are already obliged to comply with the program code there, okay, as per the code of ethics appended to the IT rules there, okay. So what's new in this front here, besides some of the points which you raised earlier? Because I think the issue there is that the advertising code was not part of the, was not appended to the IT rules here.
There is a new advertising code regarding, that is also expected because if you look at it, I think a couple of months ago, I don't remember the exact date, but digital advertising regulation was also transferred to MIB from MeitY. So you are going to see action in terms of advertising regulation online coming up as well. So, and I think there's one saving grace is that the RPP bill, which is expected to be tabled in Parliament this time, does not cover digital. Otherwise, the RPP bill, the regulation of publications and registration of publications and periodicals. And we were surprised when the first draft came out that it didn't include digital. No. So I guess that's because this bill was pending.
So this, if I could come to you on this, Abhishek, this whole idea of that, there's been sort of talk about both the program code and the advertising code being applied to online platforms. Yeah. But as far as the IT rules are concerned, the code of ethics does not sort of mention. How do you sort of try and then see the scenario?
So there are again 2 or 3 issues that are mixed in this. The first is, just to address your question straight away as to why perhaps there was no reference to the advertising code in the IT rules. IT rules had come about, of course, to address an immediate concern, which partly was also raised by some of the OTT platforms. Just the backdrop of the IT rules getting notified in 2021, if you remember, there was an entire hue and cry and some criminal actions being taken against certain OTT platforms in relation to some
Amazon and Tandav.
Correct. Some programs, etc. So, I was also representing certain clients in high courts across the country. One such program was called Your Honor. And believe it or not, an advocate had filed a PIL in one of the high courts saying that they're showing the profession in bad light because they're showing that the judge takes a bribe. Now, of course, multiple such instances have happened in the past and they will continue to be there. It's part of the story, whatever it is. Now, it may not have been an issue to be taken up by a constitutional court to really be addressed, but the question that was asked to the government then was, I see a regulatory vacuum. You have a CBFC for films, the same principles apply to television, but why don't you have anything for the OTT platforms? And they're proliferating, and that's where more and more eyeballs are sort of shifting to. So why don't you have something in place? And I think this was, I won't say it's a knee-jerk reaction, but it is one of the bases for why you had that. Now, at that point in time, practically speaking, there weren't any, or many OTT platforms which were actually showing advertisements. So their concern was to address the content, the program of what is going on. So that's perhaps the reason why the IT rules did not have an advertising code appended to it. But, with this bill addressing or encapsulating OTT as well, clearly there is an extension of the advertising code and the programming code to that platform as well. So, it's just
this is also important because it connects with the earlier point of issue of viability. Yeah.
Correct.
That's one way in which perhaps a squeeze can happen. Although the the ad code normally does not have immediate financial implications.
No.
The way it could be interpreted.
I agree with you.
And
one of the first cases which we still refer to as a precedent, the Indian Express case of the 1960s, where the issue was there's an attempt to regulate the amount of space that you could allocate on a page of a newspaper to advertising.
Yeah.
And the Supreme Court struck it down saying that effectively you're taking away the only one source of revenue. Circulation doesn't get too much money for people. Subscription doesn't get money. It's advertising that gets most of the money.
Yeah, so that was first proposed actually in the first press commission.
Correct.
And then since then it was left out.
Absolutely.
Just coming back to you, Ms. Chishti, you were talking about specific provisions. Okay.
Yeah.
What are the ones in a sense which are...
I have of course, I think this 3-tier structure which derives from the IT rules, which is under contest and also has been stayed by 2 high courts, to bring that in, and more so to bring that in as law. What was once a rule is now being brought in as a law, has serious implications. And each of these 3 structures has no avenue. It's kind of watertight, jammed by government. So the Content Evaluation Committee, the government will decide quorum. It'll decide terms of who these people are. It'll decide who these people are, i.e. broader categories, and then you pick. So that's government. Then the second level of these SROs, I think the full form is self-regulatory organizations, which is the second level. That is also full of how government will mandate how that tier is. The third tier is the Broadcast Advisory Council, and let me read that out to you as to who the Broadcast Advisory Council is. It's headed by an independent member with 25 years of experience in the media industry as chairperson, 5 ex officio officers representing MIB, Ministry of Women and Child Development, Ministry of Home Affairs, Ministry of External Affairs, Ministry of Social Justice and Empowerment, and 5 additional eminent independent persons. Now, this whole 3-tier structure, should it go through, is just government. So government will tell you what to do. If you don't do it, an SRO, which is also government, will tell you how that is wrong. And if everything does not quite work, it goes to the Broadcast Advisory Council, which is also government in different clothes, which will decide what is to be done, and then the penalty will be slammed on you. So this is just government in several clothes turning up. This is the matrix, right? And the second sort of particular clauses I have issues with, and I think that is of serious concern, is clause 31 to 35, which is about devices. So very innocuously, part of what Barkha was saying about kind of squeezing assets, what would be the asset of a small, medium type sort of show, which is, trying to put out some kind of local news or something, maybe a couple of phones, some iPads, some other gear. government can just come in, seize it, confiscate and take it away. So other than kind of putting it, separating said journalists with device, which costs a lot, you, at a time when the Supreme Court is deliberating why it is serious to take away journalists' devices, which are repositories of information, sources, not just my information, but a whole lot of other information which government may be interested in, you have now sneaked it in as a very, this is like the rap on the knuckles. So along with the fine, which could amount to 100%, of your assets, or at least 50%, and it could go into like several volumes of investments in media. You also take away my devices. And there are several clauses that kind of deal with this. So that for me is like a big concern. Something which has been like now finally understood, argued, and the Supreme Court is talking about how you cannot take away devices without hash values and all that. You're now doing this. And it's like almost a sidebar, but it's important. And I was struck when our reporter came back with the story. For NewsClick, which they've gone after, and 2 journalists are in jail under UAPA, 250 devices of 90 journalists have been seized. So just think in terms of the number of people who've been put out of business. And this, I don't even mean economic viability and all. There are just that many unwritten stories, unwritten perspectives, and things that you just won't see because it's very functional. They just have taken away your devices. 250 devices to put 2 people behind bars under UAPA.
So these are sort of devices not just owned by the organization, but perhaps also privately owned by those who are working in the organization. Mr. Again, I'll come to you about this whole idea of self-certification process. How would you self-certify, if you had to, live news?
It's very difficult. Mr. Sircar will bear this out. The same kind of debate took place with private television. And at that time, the channels were able to hit back and say, don't regulate us, we'll regulate ourselves. And so a kind of self-regulatory body was created. And frankly, it's not turned out to have been very effective. And I think that is the problem. In many ways, many of our problems are related to the malaise in television news. It has led us to this path, right? And even in instances where the self-regulating bodies would, let's say, impose a fine on a channel, the channel would not pay. If a channel was reprimanded for, let's say, hate speech, the channel wouldn't care. And then a section of broadcasters set up their own parallel sort of self-regulating mechanism. I think in the digital space, some of us tried to say, okay, let's propose. Seema can tell us better if the government ever responded, but I know that DigiPub did reach out to government saying, let's come and meet you, let's talk, let's have a round of meetings, let's brainstorm over this. There must be a way. No one is saying that there's this sort of mass of content out there, and every government would want some sort of regulatory mechanism. So we're not saying no to regulation, but let's have a chat about what that looks like. And I don't think anybody ever responded. I think that went into a sort of black hole.
Do you remember how difficult it was for DigiPub to get certified as a self-regulatory organization?
That's right.
In the first place,
That's right.
In fact, what happened was we filed an RTI asking for the procedure for certification and whether DigiPub is certified. Within 10 days of us filing the RTI, DigiPub was certified as a self-regulatory organization, and we got an RTI response saying they're already certified. Otherwise, they weren't getting it.
Yeah, but I do know that DigiPub reached out to INB ministry and said, let's have a dialogue. I mean, we were all on that call when we said, listen, let's go and talk to government. Let's go and argue this with them, but in a sort of convivial way. And I don't think that attempt went anywhere. I think that basically we have to understand that what's going to happen is that most people are going to weigh every story with the headache that it's potentially worth, right? So you're going to say to yourself, okay, I'm going to really have to pick my battles now. And isko jane do, ha, us pe chalo, let's fight. And there's a kind of looking over your shoulder the moment you start doing that, right? The moment you sort of say, even on your caption, like, I'm giving you real life examples. I know these may seem like very small examples, but just to say, what do you put on your caption for a show that you're doing? You're constantly thinking, if I put this, this could happen. If I put this could happen, right? And I think that's what we have to understand, that apart from the financial sort of squeezing of assets, there's a kind of psychological I don't know. I don't want to say warfare, but there's a kind of psychological move here, and most people on most days are going to say, I can't fight every single day of my life. So I'm going to think a lot before I speak or I write or I say something. And that is actually the most egregious impact of a proposed legislation like this without any dialogue with stakeholders.
Sure. I mean, the immediate impact of that is that if everybody sort of narrows down and remains careful about what they're going to say, there's going to be a shrinking of diversity of content here.
That's right.
Everybody will try and meet the sort of minimal point.
Can I just add a quick point here? Let's not forget that a large part of the mess that we are in as digital media, from a regulatory perspective, is being created by traditional media groups.
Yeah, exactly.
So the digital one of the things that happened with the regulation on FDI, there was an extensive amount of lobbying that happened for bringing online players under the same FDI regime, which is why you had HuffPo leaving India, you had Yahoo News shutting down in India.
That's right.
So a lot of this is, so don't expect any support from traditional media organizations who will basically come around and say, exempt us from this bill because we're already regulated.
This is a very important point. This is a really important point. Sorry.
By the way, they are exempted.
Yes.
It says clearly that traditional, all the media which have replicas of the newspapers online are exempted.
Newspapers only,
newspapers
not
only.
broadcasters. Yeah.
But they're probably already lobbied for that.
No, but it's important what Nikhil is saying, because it basically means that really cash-rich, big media houses do not have to conform to any of this, and what they've done is to squeeze the market out of competition to them. They have not, so there's going to be no media solidarity on this. Let's be very blunt and cynical about this. There's not going to be all of media banding together to stop this bill from coming.
So okay, I guess the consensus here is that we are paying for the sins of our past. Yeah, I mean,
no, we're paying
some
for their
people
sins.
are paying for somebody else's sins of the past.
Someone else's sins.
Yeah.
I think it's been dressed up as
Okay,
that.
so talking about one of the sins of the past, I'll just pick up one point on the board. Sins of the
I have one
past.
other point to make. I'll come back.
I'll come back to you, Nikhil. Sins of the past. Audience measurement.
No, before
I mean,
that,
this is. Can I just?
Prasar, I would still insist
Yeah.
that look at it from the way the Shastri Bhavan looks at it.
Right.
Because fortunately one had to work there. You see, they use the, let us say, annoyance, occasional annoyance with the entertainment sector. In their mind, world is split into news and current affairs and entertainment. The forms are different. Now, news and current affairs are more difficult to get to in terms of palpable what went wrong.
That's right.
Entertainment that way could be easier to flog. So these combo acts that they're bringing in, one after the other, combo rules that they're bringing in, are an extension of that mentality. It's not so evident in the 2007 one, because there was no hegemonic thing. If there was a regulatory thing, there was this bureaucratic overreach and all that. There were guidance, but there was no, as I said, evil intent. Here, the natural flogging horse entertainment needs to be brought into some amount of sharm. And that code of sharm is passed on to NCA. That's what happened in IT Act. That's what happening here. That's what going to happen in all their, that's a thematic thing. Now, what was this question?
Audience measurement. Talking about issues of viability.
Audience measurement.
The bill, in a sense, talks about this. It's trying to specify a methodology. If I could just finish. I'm not sure the government is capable of specifying a methodology, but that's the intent. There's been tremendous problems with audience measurement in the past, which has caused many viable broadcasters to become inviable over a period of time.
Both mic, there's a recording.
And therefore, in a sense, for me, would that be one, perhaps, positive feature of the proposal here?
Look, where Bark was concerned, there was a lot of slaving that went in. Lot of slaving, I can assure you. Government or anti-government. A lot of many midnight oil was burned, so that Bark turned out to be theoretically the best. That would be sabotaged by a foot soldier, by the last end, the ticket collector, was not perceived. Now, Bark as a theory, or Bark as an operational structure, remains very good. I still would say, even today, but it was prone to misuse both by the top, by the CEO and by the bottom. That's what happened. So Bark took months and years to formulate the neutralizing, the the disinfecting of biases, everything went in. I would still say that use the Bark example there and come up with a better model.
So there is a case where we're talking about the Bark in this case, which sort of you think it lacked a bite?
No, Bark went in, the CEO turned out to be a bad choice. I admit.
Choice by the members of...
We took it on. B, the CEO played among the rivalries of the top 5 that run it. It's run by top 5. It's not, others down the line don't get so much of a cake. Just 5 or 6 of them run it. So he played around there. And the linesman said, why not me make some money out of it? That's went wrong with Bark, but that doesn't make it. So audience measurement at an arm's length from the government is absolutely essential, because without it you can't ever gauge a proper, you can't calibrate who's due for what. So I would support an audience measurement, again like Bark, to be run by the industry. But then take lessons from what went wrong. This turned out to be a sheer oligopoly. C, that doesn't become an oligopoly. B, government took its hands completely off Bark. I was Bharat Sircar at that time, not Jawhar Sircar only. So I know we took our hands off. And C, choose the right men. They were chosen by a professional body, we agreed. It turned out to be a bad soul.
Yeah, so that's a kind of efficiency issue there. Ms. Dutt, this whole issue of, are you happy with the way in which your audiences are being measured? Is there a fair amount of data being shared by those who measure our audiences and tell you and tell all of us how popular you are? You know.
So ever since moving out of television to digital, one of the both the good and the bad of digital is there's a real time audience response. But then if you dig deeper, there are algorithms at play. There are, I often say that Indian media has gone through 3 tyrannies: the tyranny of the state, when state owned media, the tyranny of the market when commerce drove media, and now the tyranny of the algorithm. So let's not pretend that we're not all every day struggling to think, okay, what if we put these words, then will this get discovered more? So there isn't just government and regulation and legislation that we have to contend with. There's also what big technology has done. There are platforms like Facebook that have completely basically taken news off their pages. Their algorithm doesn't promote it. Yeah. So there's no point anymore putting content on Facebook. So you're dealing with this kind of invisible algo where, you're at the mercy of it. So I don't think there's a great deal of transparency within technology, big technology that we're now all dependent on to express ourselves on how our numbers are measured. But we're certainly at the mercy of them, because the money, again, please, we really have to keep linking it back to financial viability. For example, on YouTube algorithmically decides what ads to place on your content and unilaterally decides what percentage of that you will get. Now, okay, it's good. It's at least one of the technology platforms that giving you, percentage of money, and they're marketing it for you.
Their estimate of what they owe
But
you.
it's their estimate, okay, right? And they link it to their own way of measuring. And what they promote, what they put on their homepage, what is discoverable. There's no sort of neutral science to this, right? So I do think there's some merit in asking, how do we measure? Is this a fair way? But I'd rather deal with this way, ruthless as it is, merciless as it is, that I finish my program and at the end of the program I say, okay, 1,000 views or 10,000 views or 40,000 views or 100,000 views. Than with apologies to Mr. Sircar, I think this Bark and this people, TRPs and whatever, this killed television.
TV site.
No, I'm just saying in general, this obsession with ratings and linking them to commerce, it killed television. It totally shut down.
Ratings are there because of commerce. So one
No.
cannot de-link them.
No, I'm saying that the way they were measured, was very questionable. You could leave your box on all day long
Sure.
and you'd see a spike,
Yeah.
right? Secondly, I think there's some point when we have to ask, is there going to be a viable media that is not dependent on how populist you are? Because the moment you link any media, digital, broadcast or newspapers to what the dominant narrative of the time is, that means nobody's going to say anything that's even vaguely unpopular. And I think that when we talk about a free press, okay, we never talk about this, but the dependency of newspapers on government advertisements. We never talk about it, right? We think that somehow newspapers are the more honest medium in this country. You please ask the newspapers what happens to them when government pulls advertising. But if you're going to be at the mercy of government advertising, how can it not impact what you say?
So I just want to make a
Yeah,
point here,
please.
which is, it may
That's
seem...
well put in that sense
Yeah.
in terms of the double kinds of pressures which
No,
are
because
there.
you see the whole debate in the world right now, globally and particularly in Europe, you sort of see it very clearly. You see it in the States as well. The whole business of citizen, big tech and government.
Yes.
So, there is
Agreed.
this conversation which is going on. What we're finding in India is this, as somebody put it, carrots and biscuits policy to big tech, where you are completely controlling big tech through this, nice things that you do with them and scare them. So you have your 69A meetings,
69A
as
meetings.
Washington Post wrote, and you extend some largesse that come here, make your money, so we will keep quiet. So, the citizen is really in a bind, and I think why this bill worries me is that it is just putting everything together. So there's no scope now of a conversation of setting the citizens, just the citizens' jurisdiction, if you like, between big tech and government. You're pulling it all together and putting it in this basket where you're just tightening the screws, because now there's no conversation about what the responsibility of big tech is to the citizens or to government. Everything is about some loyalty check. The government has appointed itself as the arbiter and the judge, and they will decide whether you're okay or not. So I think this is distorting the debate, where the debate in India should have moved on the lines of where Europe is having these important, thorny and difficult discussions. We're away from it. And we willfully being dragged away from it because the government is planting itself there and settling it for me.
But
So
we've been away from those debates for
those-
at least
for a
25
long-
years,
That's
actually.
fine, but this
Nikhil
is
had a
an
point
important
here.
time
Yeah.
for tech-wise.
Since Section 69A was mentioned, let's not forget that the IT rules also extend Section 69A to online news organizations, and that's one of the provisions that's been stayed in the court. The government accountability committee mechanism that came in more recently, where content on social media, news content on social media could be censored, is a bypass for that Section 69A clause that has been stayed in court. And there was pushback on that as well. So essentially what you're seeing is government is also trying to, so over the years, you've seen a power shift taking place on the internet from users to platforms, and now from platforms to the government, because there's been a centralization of platforms taken place, right? So it's easier for government to regulate speech through platforms than it is to regulate 1 billion people by themselves. And so you're going to see a consolidation, a regulation creating consolidation where platforms will become more powerful, but also where that power will be controlled by the government. And I'm not just talking about this regulation. You're going to see it in every single regulation coming through. They want more big tech, even because they can flog them and essentially regulate us and speech through them.
No,
Prasar,
Nikhil
yeah.
just wanted to.
Yeah.
Sorry.
So sorry, I'm just.
I know that. Yeah, thanks very much. Yeah, thank you.
Just wanted to add to what Nikhil you were saying. The interesting part of this bill, and I don't know whether many people have actually read through the fine print. Two interesting aspects. First is, as I was talking in the beginning about the limitations constitutionally under 19.2. 19.2 does not have the word public interest.
Yes.
Public interest is in 19.6, which is an exception to the freedom of trade and profession and business. But it's not there in 19.2. But you will find the word public interest multiple times in this particular bill. And that's, to my mind, the biggest issue. Because when you, in the name of public or garb of public interest, try and regulate, then there is no limitation. That's one. Number two is that at least till now, and also in the 2007 bill, there was an intent to set up a broadcasting regulation authority, which and orders of that authority were appealable to the TDSAT, which is of course headed by a judicial member, a retired Supreme Court or a High Court judge, and technical members. In this particular bill, we see, at least I read, certain powers that were given to the TRAI and the TDSAT being taken away. And if you see, it is innocuously worded to say central government or regulator, central government or TRAI. Now, there, when you give the power to the central government to take over, then effectively you are substituting the regulator who has a certain set of guidelines to adhere to while regulating.
But that's not settled yet, right? There's that case is the TRAI versus broadcasters thing keeps happening all the time.
No. I'm not saying that.
That's not settled in law that the TRAI has regulation over broadcast.
What aspects of broadcast?
So
What aspects of broadcast?
in 2018 judgment, Justice Nariman was very clear that content is not being regulated by the TRAI. It's just carriage and aspects of that. And one of those aspects is if it's pricing and if MRP, then certainly that can be brought into within the carriage. My problem is that this bill seems to suggest that some of the powers of the TRAI are likely to be taken away by where clauses say central government or TRAI, central government or regulator. And in the absence of a regulator, my problem is there's no regulator. If there's no regulator, then there's no process to be followed to formulate regulation.
I have a question for you, Abhishek. Where in law is content regulation? I have seen codes that exist. There are uplinking and downlinking guidelines. But in law is content like this, there seems to be content regulation here in this bill, right? Does it exist anywhere else?
Only in CBFC. So Cinematograph Act, it relates to, of course, cinema halls and films to be exhibited there. And those then, when they are shown on television, the same principles apply in terms of the certification process. And there is a cable television rules which come out with the program code and advertising code. That is sought to be extended through this. But you're right. See, one of the, if I can call it that, the positives of this bill is that the disparate places where regulation or control was sought to be located, Cable Television Act, Cable Television Rules, IT rules, etc., are now all supposed to be consolidated under one head. And to that extent, I don't think it's a problem.
Is that a good thing?
I think so. You know why? Because for businesses, one of the things that Barkha was mentioning, for businesses, compliance is a cost. Now, if you have to go and say, okay, do I need to look at this legislation or that rule or new guideline, etc. Now it is all under this. One of the biggest issues that was confronting the private broadcasters was, are we licensed under the Telegraph Act or are we not licensees? And that was litigated in the Cricket Association of Bengal judgment. It was litigated time and again in various forums in Delhi High Court, Madras High Court, Supreme Court. So this at least settles that position that yes, you are a licensee. You have to operate under certain condition of license. So I think that clarity is certainly good. But what that clarity is going to ultimately breed and result in
not a fan of clarity.
Where the problem.
So it's an institutional clarity. That's why the whole idea of an integrated bill. But yet, that's one silence on the broadcast regulator. The other silence, and this is again, Mr. Sircar, this is completely silent on aspects of ownership. So the 2007 bill did make a case to sort of curb cross-media ownership here. Why do you think there has been this sort of hesitancy to not talk about it, despite neither in the bill nor in the TRAI's broadcasting policy? Although the last 5 years, TRAI has constantly been talking about the need to think about the idea of ownership.
See, when you ask Yes Bank to forget 500 crores for one of the biggest cross media owners, you're getting the message. They are desperate, as Nikhil was saying, in this triangular game between big tech, government and the citizen. Government is playing upon the fears of big tech that citizens will pounce upon you and I am your only savior. Saying the same thing to citizens, that big tech, unless I regulate big tech, you're finished. It's playing the monkey between two cats constantly, and I notice it, and I've asked my former colleagues, not necessarily friends, about this, and this comes out in the best play in the personal data bill. If you study the digital personal, it's been renamed 7 times, so I don't know what it is, DPDB, Digital Personal Data Bill.
Data Protection Bill, sir.
If you notice it, it gives a lot of leeway and elasticity to good boys in big tech, and sort of condones their depredations upon human society. It decriminalizes any act, even with criminal intent, and then also brings in hopes to the citizen that I'll be able to. You can't check big tech because big tech will dollarize you out of the legal system. You can't fight big tech. So I'm this thing. This is a constant game going on. There is, as I said in the beginning statement, it's a question of the intent. The intent is ipso facto evil. We were never told in 40 years that this has to be done. I joined during emergency, nobody told me. See, evil was concentrated in certain areas. Now it's down the line that you have to comply with. Finished. And those who are collaborating it's like Vichy France. They're just collaborating. They come up with better and better versions of domination. So I keep asking them that, yeah, you'll be retiring next year and become a common citizen, hopefully with 5 years of some sort of extension and things like that. But nobody's listening. So here, the game is clear. Use the so-called excesses or transgressions on the lifestyle of film to dominate broadcast. Use the genetic war between citizens and big tech and play on both sides. But then basically their alliance or genetic alliance is with big tech, whatever they said. X has made their deal. It's pretty clear. Facebook behaves like Facebook. As Barkha said, it has its own whims and fancies. So big tech can't be relied on excepting WhatsApp for survival. For those who are bothered about snooping, I am snooped anyway. So those who are bothered about snooping, use WhatsApp, use the other methods. That's all.
WhatsApp, I wouldn't recommend.
It's good you brought up this.
I had a quick point.
Let me finish this. I'll come to you after Seema.
Seema.
So this whole issue about, you talked about people are going to retire in a short period of time and so on and so forth. Yeah, and they normally, of course, get board positions in big tech itself. Yeah. So I think there is a clear sort of different kind of conflict of interest which is involved there. Seema, this issue about accessibility guidelines. Okay, last week I heard somebody saying that this is perhaps the best part of the bill because it's sort of,
There wasn't a brief.
It in a sense ensures that everybody, in a sense, who is impaired in different ways are able to access the websites. Yeah. Do you, in a sense, see this as, of course, is quite clearly a organizational financial burden, or do you also see it, and from a skeptical point of view, is that one of the many compliances that would then try and push you to divert some of your costs in other directions?
But I'd see it as a good diversion. So I'm on the side of kind of making it as accessible to as many people. So on this, I would say, I think it's good because some good things have a cost. And, we have no business to be going out and making it not possible for those who cannot hear, see, or, to not access. So I think that's like a good.
Because many government websites themselves, in a sense, are not fully accessible as it's supposed to be by different kind of norms.
But on this, I would like to say that that's a cost I think we should try and
You're willing to
employ.
sort of
Yes,
bear
in our
that,
own
yeah.
way. If there is, maybe you employ one person who does it for.
And you're also
shows,
multilingual.
etc.
I'm saying
We're
that's
also multilingual,
and
yes.
multi-script as well, if I'm not mistaken.
Correct,
Yeah.
but so be it.
Okay.
We jumped into that end of.
But just to add to
thing.
that, I think when the accessibility guidelines are going to be implemented, my only point is that in addition to the platforms that this bill seeks to make it mandatory, it should also be made mandatory for, let's say, theatres. Now, theatre owners do not invest because there's no compulsion right now to bring about accessibility guidelines which include closed captioning or the other aspects that are required by law. In fact, there's a matter that's going on in Delhi High Court, and MIB has specifically been directed to carry out a consultation process amongst all the stakeholders, including theatres, film producers, broadcasters, etc., and to implement this so that there is accessibility.
So I guess
to
one
content.
way is to put the exhibitors also in the definition of
Well,
broadcasters. I mean, that's a sort of skeptical way of looking at
no,
it. Yeah.
not that. Well, I think the Cinematograph Act has the possibility of because that's applicable to cinema halls. So you can
Independent
bring
of
it-
this, yeah. Nikhil, you're waiting, yeah.
So if anyone here is tweeting about this particular conversation that we are having, would you be covered under this law?
They would be.
Right? So I'm just saying, what is the threshold where user-generated content, or as Madhavan always calls it, loser-generated content, becomes a news platform? Look, I remember getting a call from another publisher maybe about 10 years ago, and he'd received a legal notice, and he used to run a blog like mine. I always see MediaNama as a blog, and his was also a blog to start with. And he's like, I've got a legal notice. We should bring all the online media platforms together and ask the government to sort of protect us, etc., etc. I'm like, I think we have more freedom of speech as blogs than we would have as media publications, right? So, what is the threshold beyond which someone becomes comes under this act? Is it like in the IT rules, significant social media intermediaries are 5 million and above, right? That's actually copied from Germany's NetzDG, where for Germany's population the threshold is 5 million.
Which is
In India, you'd launch an app and 5 million, if you do reasonably well, you will cross, because it's for registered users, right? If you have how many? If you have 1,000 followers, do you on Twitter or Instagram, do you become a news platform? How much content do you do on a news on a social media platform before you come on? How much news do you break? Most news breaks on Twitter today, right? How would you define a media publication?
So there was this thing
And so
about...
my primary problem
Yeah.
is actually of creating a framework for regulating speech of some select group of individuals who might write about news, and give more freedom to people who do not. In a sense, our freedom is being restricted. Under what threshold? Under what pretext? Under what, what is it that we are doing wrong by reporting the news or writing about the news or tweeting about it, that we are being brought under this law and bill? It's not a reasonable restriction on free speech.
Yeah, but the phrase that they are using...
If we do something illegal,
Yeah.
there are already laws to regulate
course.
that. My point is, I don't even see why newspapers need to come under a regulation. I don't even see how broadcasters need to come under a regulation. I don't see a need for this regulation, because if someone is doing something illegal, you can always act on it. So why have this kind of media regulations at all?
Because public interest is absent from all other media regulations.
I mean, this has been this big
Employment-
debate about...
Employment generation for I and B.
just a small
Yeah, so,
point.
yeah, please.
No, for me,
No, but there are laws already for libel, right? I mean, you can take the labor doctor to court. Himalayas taken the poor chap to court. Yeah. Sorry?
Social media has created grey areas on what constitutes libel.
but that's
No,
not
no,
resolved
no,
by the bill.
no, it hasn't.
The rules
Libel
remain
is
the
libel.
same.
Same.
Rules remain the same regardless of what it is.
Recently, Prasar was
No,
against
enforcement, of course, is a different matter.
Which is why it's not talked about it.
The cycle of taking a civil court action in law is what, 7 to 8 years, and because
No, and
it's better to have a regulation to control that.
No, it involves a judge. Here, the government takes it upon itself. So it's
But also the
it's
time-
circumventing
time
an important.
We'll just
sense
open
of-
this up. You had a
Yeah.
last point, Seema.
Last point. Yeah, it's the
and-
most concerning point of this bill, which I think we should really kind of talk about and think about, and which is most concerning, is how under the censorship CBFC certification rule, you have just seamlessly dragged in news. News never signed up for certification for pre-censorship. What you've done is you've taken that as a given and sneakily established this full architecture of just dragging in all news. So Ravish Kumar will have to effectively take a CBFC clearance. My colleagues who go on YouTube will have to take, it amounts to that, right? And also, it's not as if government is going to go after hate speech after this. They're going to go after whoever they want to go after. You apply all the rules to them. Clause 29, 35, 36. So for me, the most scary thing is that you've just sneaked up from behind and just dragged news into this CBFC racket.
That is, in a sense, what journalists have been constantly worried about. We can open it to the floor if there are questions, queries. Madhavan, yeah. Please introduce yourself, Madhavan, and then we'll
Is there
have
a mic?
yeah.
Because
We need a microphone. Yeah.
I'm sorry, not informed on this new bill sufficiently. My question is, we discussed big tech separately based on IT and data protection rules and also some of the content regulation issues. My question is whether the new bill also has a loop into the content regulation for big tech itself that empowers extra, there are specific micro issues for YouTube channels and all. Is there an extra provision in this new bill that enables government to arm twist, let's say, a Meta or a YouTube to put pressure, apart from other government pressures that Seema spoke extensively about?
those are already in the IT rules.
No, so there is no special provision.
Already
It's like a
No.
CC to
Okay,
them.
And
small
these are, in a
CC
sense,
mail to them.
it's incremental in a sense, yeah, the regulation.
So there's something called the GAC, the Government Accountability Committee or something. That provision allows the government to direct social media platforms to regulate news content on the platform.
That doesn't go under this,
That rule by itself is illegal because it is not backed by law.
Okay.
It's being legalized via this law. There will be separate. There's 67 areas where rules will have to be created under this law, and then there's a provision to say more rules may be created other than the issue specified. So, as news organizations, we will forever be in a cycle of, hey, every 6 months there'll be new rules, and I'm not kidding about this because it's already happening in the IT rules. Every 6 to 8 months there is a new set of rules. There was one in the middle of the year. There's one expected 7 days from now.
And Nikhil, I don't know whether most people have read this or not, but this bill empowers the government to not just regulate broadcasting organizations and broadcasting networks, but also not just individuals, also those services which they say are intrinsically linked to broadcasting.
That word is there.
I mean, this is just opening up the
What is
floodgates.
that cousins and relatives and so on?
Possibly.
Ridiculous.
Possibly.
This we just cannot.
Yeah, we have sort of opened this up. If there are questions, query. Yeah, please introduce yourself, Prashanto, and then.
Thanks, Prashanto. I'm in public policy. Just a thought that given the also concerns in the media about troll armies and censorship by majoritarianism, etc., would you folks pitch for including obligations of OTT consumers on the lines of obligations of data principles in the DVDP Act?
Prasanto, now you're trolling us.
This is friendly fire.
No? Nobody wants obligations of...
No, so look, there are at the end of again, the heart of this entire debate is what is the citizens' rights that are an issue, right? A is a right of the organization or an individual in terms of the freedom of speech and expression as to express what we want to. There is also a concomitant right of the citizen to receive that information, and that those two rights are sought to be balanced. Now, the question is, if I have that right as someone who's expressing, and I'm not transgressing the boundaries of what is provided as an exception, what I need to be looking at as terms of reasonable restrictions, then my right, so as to speak, will perhaps trump the rights of the person who's receiving that. Now, where are these boundaries getting blurred? I mean, increasingly they are, but I don't think that there is a need to bring in this element into this particular debate. This is my view.
Abhishek, I think Prasanto was asking more about fundamental duties rather than fundamental rights.
No, which is I'm saying. So I'm saying that to my mind,
as we know, fundamental duties override fundamental rights in some kinds of countries.
Well,
in some kinds of countries.
Not in ours, unfortunately.
Yeah, Mr. Bhushan.
So, Nikhil, you said that all kinds of illegalities can be dealt with by the law, but now you have a regulator. So the regulator, for example, finds Wire or tries to close down Wire, but one Mr. Shah or Patel goes to Gujarat High Court and also files a FIR against them for whatever they're doing. So you get punished twice over. by the regulator who shuts you down and by somebody who wants to put you in
But
jail.
through a regulator.
By the regulator, you mean
So the broadcast regulator has
So
the
that's a
powers.
government
That's
only.
the point I said, that there is no, this bill
is
does
no
not
regulator.
anticipate, envisage a regulator. Unfortunately, there are no principles of
So
regulation that we
whoever
have to
fines
adhere
you,
to.
if there's not a regulator, but there's provision for fine.
Yeah.
Same
So,
entity.
so same entity, it fines you, but also then somebody else tries to put you in jail for the same thing. So for the same so-called crime, you get punished twice.
So there is some precedence here in the online streaming services industry, where they actually finally welcomed the regulation that came in, because there were cases being filed against them all across the country. Some of those cases were fairly motivated and politically motivated. And what happened once the regulatory framework came in was that those cases stopped because the court said, first file a grievance, etc. and go through the entire process, and then
step by step.
Then court is your last recourse. In the data protection bill, we've seen them going one step further, where they're saying that you can't go to court. You have to first go to the regulator, then you have to go to the appellate authority, which is supposed to be TDSAT, which does not have the capacity to deal with anything right now. And then you can go to court. So you can't go to court if your data has been leaked. You first have to go to the regulator. So I think at some level, platforms and news platforms might welcome that regulatory framework, because otherwise busybodies will go and file cases against them
Coming back to,
everywhere.
in a sense, what Abhishek was saying about this idea of this integrated thing. Yeah, ma'am, please.
Yeah, so I'm Vani. I represent Index. So we see that there's always been a resistance to have a broadcasting regulator per se. So right now, if we do away with the bill completely and we think of a regulator, or do we see the bill as the regulator? So like, if there were to be a regulator, would the bill be like a blueprint for the regulator?
Will the powers which are there in the bill be transferred to that
the
entity
regulator.
called the invisible regulator, as Seema was saying? Yeah.
No, there is a very visible regulator because it's a government.
It's not the regulator. It's
It's ascribing to itself
that's the line
all
with-
the stuff it's controlling, and it's terming it regulation. And
Legitimizing its power.
it's the biggest typo on the planet. You call it regulation, you're controlling.
See, the fundamental principles of regulation, and subject to, of course, correction by Mr. Sircar, from what I have actually seen is that the default proposition, or where the regulator ultimately wants to achieve in terms of utopia, is that there should be no regulation. The market and the people and the actors are able to take care of themselves. So there is self-regulation there. Everyone is happy, right? To achieve that is why regulations are put in place. But when you are putting in regulations in place or a regulatory structure, there are principles to be followed, including transparency, including public discussion, including a continuous monitoring of it by experts who are supposed to have that knowledge. That, unfortunately, is completely absent from this bill. And that's the problem.
I'm not sure if that's, in that sense, having a separate regulator, the absence of that is a bad thing. Because quite often when you get a regulator, the regulator also has to justify its existence. And so therefore they keep regulating.
I agree with you, which is what I'm saying. Utopian ideal is for there to be laissez-faire, right?
Yeah.
But the point is, what is better? Is it better to have a regulator which is bound by certain principles, time-tested principles, constitutionally safeguards, or not to have any regulation at all and then be at the mercy of public interest?
Also, Nikhil, typically if you look at regulators globally, their bulk of their energy doesn't go into regulation. It goes into monitoring and collecting evidence here. Okay, and I think there's a big difference in terms of we are not used to this idea of collecting evidence that might inform decision one way or the other. Yeah, all this is completely in the absence of evidence.
Correct.
Even the cross-media regulations proposed in 2007 were in the absence of whether or not there's a cross-media threat.
Correct. And anyway, we're a country that sees lawmaking as a solution to problems rather than enforcing the laws that already exist.
Already exists. But yeah, I'm saying in terms of regulator, that job
with
is
no
a little
offense to the lawmaker.
Yeah, there's a question here, ma'am.
I'm an MP for no fault of mine.
Well, Ma'am, yeah. Could you please introduce yourself, ma'am, and then yeah.
Yeah, I'm Sucharita. I'm an activist, a women's rights activist. My question, I have two questions actually. One,
You want to direct them to particular speakers?
okay, or anybody who thinks you can address it. One is, suppose a private corporate house files a defamation case against a media platform because of something that you have exposed. Huh? So they file a defamation case and that goes to the court and so on and so forth. Where does the regulator come in? What is the role of the regulator in such a case? Is it considered as between two private parties? Or what? I mean, you just fight it out in court, whatever
No,
you
so
do,
the legislation
like
around
happens at this time, no?
Yeah.
I mean, right now what happens in such a case? How is it going to be different? Is the regulator going to have any role in this?
regulator is not supposed to regulate the so as Nikhil said, there is already a law on defamation. That is an exception or a restriction on free speech.
Right.
But there are there are defenses to defamation. There is a claim against you for defamation. You will have a defense that no, this is the truth, and truth is an absolute defense to defamation. But that's a private dispute between the person who's claiming to be defamed and the person who's allegedly defamed. This person. So therefore, that the regulator doesn't step in, and if the regulator steps in, there it's a problem.
Okay.
So just reminded me that when we first set up the Internet Freedom Foundation, Apar and I, the first thing that we worked on was a law for decriminalization of defamation. And we put it to a public consultation in terms of principles. Unfortunately, and we drafted it for Mr. Tathagat Satpathy, who was also a media publisher. Unfortunately, that never made it to Parliament as a private member's bill at that time. But if there's one regulation we need now from the media science standpoint, is decriminalization of defamation.
I think in our region only Sri Lanka seems to have sort of moved in that direction, in the sort of South Asian region, towards that direction.
My other
Sorry,
question
ma'am had two questions, and then sir, and then sir. Yeah.
There was a reference to threshold here. One of you talked about that, right? So, like, any media platform has a certain audience. So, does this threshold, is there a threshold on what minimum audience you must have in order to come under these rules? Under this,
it's not specified here. I think that
those rules might be made later, like many other rules. But I started.
Suppose I'm running a very small organization.
I started by writing for myself.
Okay. Then.
Now I have an audience.
So then what happens?
Nothing. I don't want to be under regulation.
But is there a threshold?
There is no threshold.
Not yet. So those sort of rules will be derived once this put us into an act.
Right now, it's not specified.
Not specified as of now in terms
much
of
audience
the idea of a threshold and so on and so forth. And of course, by the time they specify that threshold, of course, the threshold has changed because things take such a long time to actually function here. Yeah.
I think Puranjay is there.
Puranjay.
Yeah. Thank you. A few observations and a question. Nikhil, Justice Deepak Mishra ruled that defamation can be both a criminal offense and a civil offense. Does this mean that when you say decriminalization, that you move to a bigger bench of the Supreme Court or your review petition? I mean, that's the first.
Pass a law. You don't need to go to the court for that.
I see. Assuming that, our lawmakers will pass it. Good question.
Fingers crossed.
Seema, at present there are more than 300 personal electronic devices with the Delhi police. It's been 2 months.
Yeah.
They belong to, or they were used by 80 individuals, most of them journalists and others associated with NewsClick. The Supreme Court has asked the government to give a set of rules or guidelines. Under what circumstances can you seize personal electronic devices of journalists in particular, because you are depriving them of their livelihood? What do you think? I mean, we can guess what the government might say, but what is the way forward? Again, do we seek to go to another court and say, look, you cannot do this, whether it's under the UAPA or any other law? That's a question I had for you.
I would sort of make it eminently impossible almost for this to happen, or have like a really high bar. So you can't come to any journalist and just pick up devices like that and take it away without any hash values. You know that very well, about without any hash values being given, without any recording of that, and pretend it's business as usual, and then harass people even for taking it away. So I think, I mean, I just love the courts. I mean, to make it as small a question as, oh, it's just a livelihood being. There's just so much more at stake here. It's almost sort of human lives may be involved in information that may be there in people's devices and journalistic devices. So I don't envisage going to another court, but I was actually quite hopeful that the discussion had at least kind of got to a point where people were thinking about this. Because it was just happening, you know, the banality of it all, it was just happening like that. So at least the Supreme Court is cognizant of it. It forced, you know, a lot of devices to be returned. So just when that discussion matured.
It happened in the case of Wire.
Yeah.
After a year.
Yes.
It hasn't happened in the case of those associated with NewsClick.
But I think there's going to be a bigger hearing in the Supreme Court. I think it's kind of coming up.
We are all hoping for that.
Yes, but that's still better than the casual way in which this bill says that you can just walk in, seize, take away, and it's all part. And also then it's law. Right now you're told that the cops have taken it away. You see, right, then you just kind of elevate it to the Hammurabi Code, as it were. You know. So.
I had a question for, if I may, one small question.
Can I just give a quick suggestion?
Yes, to the lawyer. Yes, please.
Very quickly.
Suggestion.
Every journalist should just have dissipating messages on and use only Signal. That's
no
the
Telegram,
ideal situation.
no WhatsApp.
Telegram never. WhatsApp maybe. But Signal with dissipating messages is ideal.
Okay, we'll do a how-to session, I think, at some point of time.
No,
and,
I had a.
And this is really important. But I mean, this is.
Vibod, I had a question for the lawyer,
Mr. Malhotra.
Mr. Abhishek Malhotra. Does a citizen have any right to redressal of her or his grievances if he or she is defamed by a troll? The troll is anonymous. The troll is whoever that person is, paid for or not paid for. Can an individual, does she or he have any right to redressal of a grievance? Because what happens in all these digital platforms, they have these so-called community standards. And 90% or even 99% of the times, these meets are community standards. If somebody calls you MCBC, the algorithm says you are the master of ceremonies, or this has happened before Christ. You can't do anything about it. Or can you?
Yeah, so thankfully the answer, as in most cases that I find it to be, is there in the older precedents which have, from time immemorial, since defamation law has come into place, has held both the person who's allegedly defaming and the publication which carries that defamatory statement or remark, equally liable. So now the publisher also needs to exercise that due diligence to ensure that the defamatory statement that is being carried is either excised, or at least when they are brought, their attention is brought to that, then they take it down. So yes, there is a redressal mechanism available, but as in other cases of defamation as well, the publication has already taken place. So it's more difficult to stop a pre-publication than it is to stop something which is published. So you can at least be taken down.
So when you have a digital monopoly, like say Twitter,
yeah,
what do you do?
So you basically sue Twitter. And you say that, look, this is there is a takedown provision that they have as per their terms and conditions. So you write to them asking them to take it down. And if they don't do that, then you take them to court.
Would that mean that Twitter is a publisher and not an intermediary?
Because if it
Abhishek,
fails to...
You first have to get a court order under Shreya Singh.
No, so I know. But what happens is very often a lot of platforms, because of the fact that they don't want to be taken to court, are in compliance with certain aspects which are, clear. Now, defamatory statement may not be clear, and in that case, ultimately, you will have to go to court and get an order.
There is a question there, gentlemen. Yeah.
And on the anonymity front, then there is also a case that WhatsApp has filed to protect end-to-end encryption. So it's anonymity versus privacy. That battle is a separate discussion.
So please introduce yourself.
And my name is Yaqub, and I work with a law consulting firm. My question is on institutional independence. So if you look into the bill, the institutions under the bill, it shows that the bill has not incorporated the idea of institutional independence and autonomy. And it's not just this bill. Even it happened with Data Protection Act, Telecom Bill. So there is a move to, there is this attempt to move towards command and control governance, and with less institutional independence or zero institutional independence and autonomy. So my question is, how do you see the question of institutional independence and its impact on creativity,
on journalism,
cinema,
just to be more precise,
or journalistic
actually,
freedom?
Yeah.
Yeah.
Seema, would you like to take that? The erosion of institutions and the impact of that on what you do.
I think the sort of floor is strewn with evidence of what you've just said. So, I mean, the answers are there in what's happening, because, I mean, the only way in which real life democracy can be lived by its citizens, whether it is exercising creative pursuits or just being free or independent, is through institutions. So I think damaging those institutions, often seriously and often beyond repair, is leading to a very deleterious kind of an impact on our lives, as you see. So yeah, it's a matter of grave concern where institutions, all manner of independent institutions which are meant to kind of keep the wheels of democracy going, are being eroded like that.
Last question.
Few questions to them.
My name is
just this last one, and then
my name
we
is
have to
Sagar.
wrap.
I run a small, website. My question goes on. In 75 years of our independence, we are, harping on media freedom. And all of a sudden, when a regulation, broadcasting bill comes, and we find all the media people bowing down to this, why can't we stand up and, ask the government to demolish this type of bill by giving various reasons for the sake of bill not to come in the parliament, or we come up with the hue and cry, because unless and until, if you are in democracy, the sovereignty, you call yourself republic, by lots of name you have, and once you paint this bill, so the media freedom goes down, you're not republic even. So what's your take on the subject?
Yeah, I think Barkha had mentioned this, that the idea of thinking of the press world as a whole in terms of we, W capital, that seems to have been fragmented there. So perhaps one has to go back to some of the fundamentals to see that, what are the various kinds of constituents that like to see themselves as representing one type of the press as opposed to the other. Yeah.
Also, there are folks who've gone to court challenging some of the rules that have come up. There were issues repeatedly raised about the IT rules that was once they came out, because there was no public consultation before the news segment came out. It's not that any of this has happened without protest. Let's be clear about that. It's happened despite protest.
Which is the point which, in a sense, she was making in terms of the fractures within the so-called press. Yeah. I think we have to.
So we have to end here.
Call it a day.
Unfortunately, although
Thanks
this has
very
been
much.
an absolutely riveting discussion. Thank you so much for all the panelists who took the time to come here and join and participate in this discussion. A lot of important points have been thrown up, and as Bharat mentioned, we are going to glean some of these points and use it as a submission to the ministry, because the bill is open for public consultation. So thanks all the panelists, Nikhil especially, who was so sporting, and he had injured his foot, and that's why we got him, in fact, blessing in disguise. And thank you to the audience. You've come out in large numbers. Thank you so much for participating in the discussion as well. And a big thank you to IIC for partnering with the Media Foundation and, on this initiative. So, good night, everybody.
Thanks very much. Thank you. After a long time, actually. Yeah. So, yeah. Thank you.
Thanks.
So, hey, I will take your number.